Hello and welcome to yet another episode of the PT Special Series. Now, in the first segment of this particular subject, we covered very important current affairs. Similarly, we are going to do it in this episode. The first one is Section 66A of the IT Act. What is it? What is the important features of it? Why the Supreme Court is not very happy about it? Let's talk about that. So, the Supreme Court has issued a notice to the centre on the use of Section 66A of the IT Act, and the provision was struck down. Still it is being used. In which case was it struck down? In Shreya Singhal case of 2015, and it was held unconstitutional, also a violation of free speech. The IT Act, it penalizes various forms of cyber crime, so that is why IT Act is important, but Section 66A is certainly a bone of contention. 66A penalizes dissemination of information which is offensive, dangerous and insulting. Such undefined terms, because the definition is not clear, that is why it was unconstitutional, and free speech was being hindered because of the not defined nature of these things. Okay, such undefined terms do not fall among the exceptions granted under Article 19 Clause 2. That has been said by the Supreme Court itself. Now, determination of offence under Section 66A is subjective discretion of the police. This is open to abuse, and that is why this has been struck down. Shreya Singhal case of 2015 is related to Section 66A of the IT Act. The section is contrary to both Article 19, that is freedom of expression, and 21, right to life and liberty of the Constitution. Right to know, part of the right to speech and expression is provided under Article 19 Clause 1 subclause A. Right to know, if I have to exercise my freedom of speech, I will be able to do so only when I have the knowledge. So that is why. Section 69A and 79 of the IT Act were not struck down by SC in this case. A tricky question could be asked. Section 66A, 69A and 79 were struck down in the Shreya Singhal case. No, only 66A was struck down. Moving on, let's talk about more. 69A, what is the Section 69A? It has the power, under it the centre has the power to issue directions to block public access of any information through any computer resources. So keywords computer resources here. 79 provides for exemption from liability of intermediary in certain cases. Intermediary is a person who is just passing on the information and not actively involved in it. Okay, so intermediary is like Twitter is there, intermediary, Facebook is there. Emigration Bill 2021, let's know about this bill. Ministry of External Affairs has notified this bill, and basically it was for public opinion. Okay, and aim is to reform the recruitment process for Indians seeking employment abroad. Now this could be very tricky if you do not know about the Emigration Bill. It enforces the reform is the enforcement process or for the recruitment of Indians who are seeking employment abroad. Emigration, not immigration. Okay, and replaces the Emigration Act of 1983. It could be asked in your prelims examination. This particular bill intends to replace which Emigration Act of 1983, and it proposes a three-tier institution framework. There should be a three-tier institution hierarchy should be such: new immigration policy, division in Ministry of External Affairs, Bureau of Immigration Policy and Planning, and a Bureau of Immigration Administration. Also nodal agencies under a Chief Immigration Officer, and it envisages comprehensive immigration management as well. Basically, in order to reduce and mitigate, also if not completely, expel the indecency, the unjust nature that and unjust treatment that is meted out to Indian immigrants. So for that only this process has been evolved. Institutes regulatory mechanisms governing overseas employment of Indians. Okay. Also, it establishes framework for protection and welfare of immigrants, punishment to workers for violating provisions, passport can be cancelled or suspended, and fines up to rupees 50,000. Punitive measures, remember that. What are the punishments under it? Crackdown on migration through unregistered brokers, because this is a very proliferating agency, and unregistered brokers, they give rise to human trafficking. Authorities will have powers of civil code. This is a very important preliminary fact. authorities will have a power of civil court. Remember that. Okay. Moving on. Like the next topic is with respect to draft drones bill. About drones, you have to be careful about how the categorization of drones happen. Remember that. Okay. The draft of drone rules 2021 has been released by Ministry of Civil Aviation. Okay. It is built on a premise of trust, self-certification and non-intrusive monitoring. Non-intrusive monitoring meaning that it is not intruding into anyone's space. That means privacy. Trust, that means whoever is operating the drone is trustworthy with its own instincts that I am ready to use my drone in a non-intrusive manner, and self-certification so that the industry of drones expand. Okay, more the hard the certification, the less will be the chances of the industries to expand. In this case, it replaces the unmanned aircraft system rules of 2021 and the fee is reduced. No linkage with the size of the drone. Fee is reduced and there is no linkage with the size of the drone, whatever the size is. As I told you, have a basic study about the drones, the categories, micro, mini, like that. Safety features: no permission, no takeoff, real-time tracking beacon, geofencing, etc. These are included in the drone. A digital sky platform will also be developed and a business-friendly single-window online system will be developed. Minimal human interface so that it's only about documents and not people. Self-generated permissions, interactive airspace map with green, yellow and red zones so that categorization can also take place and security can be upheld. Flight permission not required. Important prelims fact. Up to 400 feet in green zone. Yellow zone has been reduced from 45 km to 12 km from the airport parameter. Earlier it was 45, now it is just 12 and the yellow zone we are talking about here. No restriction on drone operation by foreign companies which are registered in India. Tricky question could be asked. There is no restriction on drone operation by foreign companies which are registered anywhere in the world. No, only we are talking about India. Drone corridors will be developed for cargo delivery. Proper corridors which are specified to drones will be developed so that efficient working of drones can happen and no accidents are there. Moving on, the no pilot license required for micro and nano drones. Earlier it was there, but now pilot license is not required for micro and nano drones. And for research and development organization, there is an exception. It is only for non-commercial use. Okay, for commercial use, there is a requirement of pilot license. Drone Promotion Council to be set up so that proper working of the drones, the entire process, how the mapping has been done, are the maps proper or not, the proper proliferation of industry is happening or not, will be taken care of by it. Easier process which is prescribed for transfer, also deregistration of drones. Maximum penalty has been reduced to rupees 1 lakh only. Okay, let's move forward talking about the next particular topic. Provisions of 97th Amendment struck down. Okay, so Supreme Court has struck down certain features or provisions of the 97th Constitutional Amendment Act of 2011 and Supreme Court upheld a judgment of 2013 of the Gujarat High Court. What has happened? The amendment has shrank the exclusive authority of states over its cooperative societies. Now, amendment, what has it done? There were exclusive rights of the states over its cooperative societies. It has shrunk down. Cooperative societies under entry 32, they are in the state list of Schedule 7. Remember that. Schedule 7 has list, union, state and concurrent, and cooperative societies are under the state list. Okay. 97th Amendment Act introduced Part 9B of the Constitution, which was dedicated to cooperative societies, and it dictated the terms for running cooperative society, how to run them, everything. Is there any DPSP which is related to cooperative society? Remember and comment about it. Okay. Amendment required ratification by at least 1/2 of the state legislatures, and ratification not done. That is why struck down, because ratification wasn't done, it was struck down. Supreme Court upheld the provisions which were related to multi-state cooperative society. Now, Union has the power to legislate on the multi-state cooperative society because it is working in multiple states. Also, 97th Constitutional Amendment Act added the word cooperatives. Very important, very easy if you know about the features of it. 97th Constitutional Amendment Act, it added the word cooperatives in Article 19, Clause 1, Subclause C. Now, Article 43B in the Directive Principles of State Policy is dealing with the promotion of cooperative society, a question which I just asked. I hope you have answered it correctly. Moving on. Cooperative societies has many features. First, in 2012, the International Year of Cooperatives was celebrated. And when? 2012, remember. 97th Constitutional Amendment Act, it made cooperatives a fundamental right. Very important. Another important feature. A separate Ministry of Cooperative was formed by the center under the leadership of Amit Shah. Vision is prosperity through cooperative. This is the vision of it, prosperity through cooperative. And world's biggest cooperative movement has been done in India. World's biggest cooperative movement in which country? India. Let's talk about delimitation in Jammu and Kashmir. About it, the draft report has been released, and the delimitation exercise of Jammu and Kashmir in the past has been different. The final document has also come. We have covered that in our news series. Delimitation of assembly seats was governed by two acts. First was the Jammu and Kashmir Constitution and the Jammu and Kashmir Representation of People Act of 1957. Their seats were their seats in the Parliament was according to the Indian law, but their seats in the state legislature was in accordance with the state law. Okay, moving on. However, abrogation of the special status, Article 370, in 2019 has made it important that delimitation should be done so that proper seats can be formed and they could be filled and represented. It was divided into two categories. Jammu Kashmir had state assembly and Ladakh did not. So delimitation of assembly and parliament is in the union territories. That happened. So Special Delimitation Commission was constituted on 6th March 2020 specific to the needs of the union territory of Jammu and Kashmir. The commission has been headed by Justice Ranjana Prakash Desai. She is a retired Supreme Court judge. So remember this name, Justice Ranjana Desai, Prakash Desai. Other members also included Sushil Chandra, who was the Chief Election Commissioner, former, K.K. Sharma, the State Election Commissioner of Jammu and Kashmir. Commission proposed 7 new constituencies, 6 in Jammu and 1 in Kashmir, okay, in the assembly. Now this has been finalized. Just follow through the in news of Drishti IAS English. For Hindi medium, Hindi is separate. Now, total number of assembly constituencies will rise from 83 to 90. It also proposed 7 scheduled caste and scheduled tribe constituencies in the region, and the number of Lok Sabha seats have been kept 5. This is according to the draft. For the final and many more details, just follow in news of Drishti IAS Delimitation Commission, Jammu and Kashmir. Okay, no seat has been reserved for SC and ST in the Lok Sabha. Okay, delimitation is fixing the boundary of a region for election purposes. Okay, and emphasis is on keeping the number of voters in the constituency almost equal. This is because of course, that equality should be upheld. Parliament enacts a Delimitation Commission Act for forming the commission after every census. For India, it has been done 4 times. Okay. And Union government sets up the Delimitation Commission, which is a non-constitutional but a statutory body because it is done under the Act. It is appointed by the President. It is notified by the President, and who all are included in the Delimitation Commission? The retired Supreme Court Judge, Chief Election Commissioner, and respective state election commissioners. Moving on. Now, this is a question with respect to UPSC prelims. With reference to Delimitation Commission, consider the following statements. The orders of the Delimitation Commission cannot be challenged in a court of law. When the orders of the Delimitation Commissioner are laid before the Lok Sabha or the State Legislative Assembly, they cannot affect any modifications in the orders. So, yes, both are actually true because it is a very powerful body. It is not something like it is just a body, statutory body, nothing else matters about Delimitation Commission. So, the states and the Lok Sabha, State Legislative Assembly cannot make any modification. The law, whatever judgment has been passed by the Delimitation Commission cannot be asked or questioned in the court, any court. So both are correct. Both is the correct answer. Now, Anti-Trafficking Bill of 2021. Ministry of Women and Child Development has released this particular bill. Who has released? Anti-Trafficking Bill. Trafficking is related to humans, mostly humans. So, who will be responsible? It could be asked, Ministry of Social Justice and Empowerment. Remember, it's Women and Child Development. Trafficking in Persons Bill, Prevention, Care and Rehabilitation Bill 2021 is the name, and it extends to all citizens within and outside India. Very tricky. It extends to citizens only within India. No, outside India, because if they have been trafficked, they must have been carried to some other country as well. Persons on any ship or aircraft registered in India or carrying Indian citizens. This is the ambit of the bill. And a foreigner having a residence in India at the time of offence under this act. Then includes every offence of trafficking with cross-border implication. Then victim now includes not only women and children but also transgenders, along with women and children, of course. Offenders too include anyone in a position of authority like defense personnel, government servants and doctors. Provision is there for life imprisonment and even death penalty. Capital punishment is also there. So be very careful with this bill. In the sense, be very careful with the provisions, remember them. Okay. And property brought via such, bought via such income is used for which was garnered from trafficking any person has to be forfeited. Investigation agency, what is the investigation agency under it? National Investigation Agency, very powerful body. And center is constituting a National Anti-Human Trafficking Committee as well. The state and district level committee will also be operating article. So a question could be asked that only a national level committee is there? No, state as well as district level is also there. 3. Article 23 clause 1 prohibits trafficking in human beings, fundamental right, of course. And then Immoral Traffic Prevention Act of 1956, it penalizes trafficking for commercial and sexual exploitation, Also, international conventions, if we talk about from the prism of trafficking, we have UN Convention Against Transnational Organizational Crime, and it is implemented by the United Nations Office of Drugs and Crimes, UNODC. Remember this? This is an agency. So it could be asked, who implements this? Which organization implements UN Convention Against Transnational Organized Crime? Options would be given. So UNODC is responsible. Blue Heart campaign by the same institute. Protocol against the smuggling of migrants by the Land, Sea and Air. Universal Declaration of Human Rights, of course. So these are the important things that we have to remember from the perspective of this bill. Next comes the previous year question. Which of the following are envisaged by the rights against exploitation in the Constitution of India? Prohibition of traffic in human beings and forced labor. Abolition of untouchability. Protection of interest of minorities. Prohibition of employment of children in factories and mines. So only 1 and 4 are correct. That is why C is the correct answer. I hope you are making all this up. Now let's talk about preventive detention. Supreme Court has gave a verdict on the use and applicability of preventive detention. What is preventive detention? It is basically to restrain a person through captivity in order for that person not to commit any crime. If a person is going to commit any crime, in order to restrain that person, the person will be held in detention. That is preventive detention. State should not arbitrarily resort to preventive detention. It should not be done in trivial cases because that is threat to law and order break. Because threat to law and order cannot be the sole basis here, as it infringes upon the Article 21 right to life and liberty, and it could be used only to prevent public disorders. Okay, remember that. That is said by the Supreme Court. Can only be done so in whenever there could be a public disorder. Okay, the Article 21 should be read with Article 22 and the statute in the question. What is Article 22? Tell me in the comment segment. Be interactive. Okay. Preventive detention is detaining a person in order to prevent him. This has been discussed, so I will leave this. Action is taken on the ground of suspicion. Very subject to interpretation. How will you define suspicion? Article 21, right to life and personal liberty. Article 22, clause 1, right to be informed of the arrest and right to consult a legal practitioner of choice. Remember this. Right to be informed. Why are you being in detention? You have the right to consult any legal practitioner, of course. And Article 22, clause 3, subclause B allows preventive detention. This could be asked very straightforward in your prelims examination. Moving on. Protection under Article 22, clause 1 may not apply in case of preventive detention. And Article 22, clause 4 can be of maximum 3 months. This is the limit. Okay. center and state can make laws on the subject. Tricky question. Only center can make laws on the subject of preventive detention. No, state can also do so. It is a subject in the concurrent list, and that is the reason state and center both are doing it. So moving on, let's talk about the preventive detention laws made by the parliament. Many laws have been made under this. No other country has so many laws as much as ours does. Okay, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. National Security Act is done under it only, of 1980. Okay, 11th extension of the term of commission under Article 340. I hope you know about this. This is actually with respect to Rohini Commission. 11th extension of the term of commission constituted under Article 340. It was appointed to examine subcategorization of the other backward classes. Now there is backward classes, then also there is subcategorization under the backward classes. So like that, for that only this commission was made, Rohini Commission, very famous. It was under the retired Chief Justice J.G. Rohini. Okay, President can appoint a commission under Article 340. Who can do so? Who can appoint a commission with respect to OBC? Governor, state government, Prime Minister, President is the correct answer here. And to investigate the conditions of socially and educationally backward classes. This has been done. He may appoint such number of persons as he may think fit. So there is no threshold with respect to that. The commission presents the report to the president, making the recommendation, and the president puts it before the parliament. This is the protocol that has been followed with most of the reports. 102nd Constitution Amendment Act of 2018. It provides constitution basis to NCBC, and earlier it was not a constitutional body, but now it has become a constitutional body. It comes under the constitution now, and with respect to which amendment? 102nd Amendment, remember that, of 2018. Okay, so the act inserted two articles, 338B and 342A. Okay, 338A, Article 338A, National Commission for Backward Classes, it authorizes NCBC for matters which are related to backward classes, and the president has to specify socially and educationally backward classes in states and union territories. Who does it? Governor, state government, president, or central government. It's the duty of the president under Article 342A. Okay, and the parliament can amend. Parliament has the rights to amend the SCBC's list by law. Now in 2015, National Commission for Backward Classes recommended, what did it recommend? OBC should be categorized into extremely backward classes and more backward classes and backward classes. So subcategorization should be done. But what are the parameters for doing so? Related commissions, other commissions are there. Kelkar Commission 1953 and Mandal Commission of 1980. So Rohini Commission, Kelkar Commission and Mandal Commission, these all are related to other backward classes. Moving on, Supreme Court strikes down Vanniyar quota. Okay, so the Supreme Court has struck down 10.5% reservation for Vanniyars in Tamil Nadu within most backward classes. And the Tamil Nadu government actually enacted the Special Reservation Act in 2001, which provided for 10.5% reservation of the total 20% MBC quota for Vanniyakula Kshatriyas. Okay, Vanniyakula Kshatriyas alone, citing backwardness. They were saying that they were backward. So the Supreme Court has cited Indra Sawhney case of 1992, when caste can be the basis of reservation, but it cannot be the sole basis. So whenever we are giving reservation, caste has to play an important role there, but not the sole one. If any caste which is socially backward but educationally very forward, or it is economically very forward, then those factors have also to be considered. No quantifiable data is there which can show what is the relative backwardness of the Vanniyar community. There is a lack of data with respect to showing the backwardness. That is why it was struck down, and no substantial basis to treat Vanniyars as a separate group compared to others among the MBCs. Okay, so these are the main things. Supreme Court has cited absence of updated caste-based data first. Secondly, it was done solely on the basis of numbers. What is the number? 13.1% of the state's total population. What if they are extremely forward, if they are well-to-do economically? And reservation in Tamil Nadu is already 69% under a 1994 Act, protected under the 9th schedule. So 9th schedule has all those, it shelters all those acts which cannot be reviewed by the judiciary. So you see that it is already under the protection of 1994 Act. The most of the reservation in Tamil Nadu. Now again, reservation after reservation is not good for the society. So moving on, more data, Christians and Muslims are 30%, MBC is 20%, so scheduled caste and tribe, you see scheduled caste 18%, tribes are only 1%. Now, the law violates the fundamental rights of equality, non-discrimination and equal opportunity of 115 other MBCs are denotified communities. It was unjust in nature. And no bar on state to enact law subclassifying within identified backward classes. So they can, although this was struck down, they can still classify within the OBCs. Okay, subclassification is not debarred. Okay, so that's it for today. Tomorrow we shall meet again with another episode. Until then, stay updated. Thank you so much for watching.